Division bench, item 1 for orders.
May it please your lordship. Lordship may be pleased to hear the other sides if they have any further submissions to make. But at the end, I would like to place a judgment of the Honorable Supreme Court, which was delivered on 28th of May 2025.
Okay.
So that opportunity may be given to me. That has a direct semblance with the present factual matrix also.
Okay. Please, my lord, no further submissions from my side. Okay. So, Mr. Segia.
Yes, Lordship. So, Lordship, this is a recent judgment of the Honorable Supreme Court in Muhammad Arif Muhammad Yasin Jawaddar versus State of Assam. And Lordship will kindly come to paragraph 2. This appeal is directed against the judgment of 27/1/2023, impugned judgment.
Just give the citation so that Mr. Gonsalves can follow.
Yes, 2025 Supreme Court Online, 2025 Supreme Court Online SC 1251. Arif Muhammad Yasin Jawaddar versus State of Assam. I think they, whether the other side, yeah, anyway. So I think they have received it. So paragraph 3, Lordship. This appeal is directed against a judgment dated 27/1/2023, whereby the High Court of Guwahati dismissed PIL 86 of 2021 inter alia seeking a record of all the fake encounters of the state of Assam, registration of affairs against the erring police officials, independent investigation against such officials in compliance with the guidelines laid down by this court in PUCL versus State of Maharashtra. The petition was dismissed by the High Court, holding that PIL was premature and the documents placed on record only made out vague assertions. Nevertheless, the High Court directed that the appellants shall be provided all legally permissible documents in connection with all the cases if so applied. The appellant is before us asserting that no meaningful, effective inquiry has been undertaken in respect of these cases and the guidelines laid down in PUCL has been flouted blatantly. Paragraph 5.1. The appellant in the writ petition filed before the High Court alleged that as many as 80 fake encounters took place in the state of Assam between May 2021 and December 2021. According to him, 28 persons were killed and 48 were left injured during these encounters. It was further alleged that the police authorities have justified these actions on the basis of escape attempts from the accused persons prompted them to open the fire in purported self-defense, resulting in death or injury. Then I'm skipping all this part. Now, contention before the appellant. Next page, paragraph 6. Mr. Prashant Bhushan, learned counsel for the appellant, strongly contended that the High Court had failed in error in overlooking the fact that 56 persons have lost their lives and 145 have been grievously injured in police encounters. According to him, the guidelines laid down in PUCL were not adhered to in any of these incidents. Yeah. So the details are given here. Now coming to next page. They also wanted a CBI inquiry. Then contention on behalf of the state respondents, so and so appeared for the state. Their submission are summarized as well. The issue raised in the instant petitions are vague, baseless, and whimsical, and the High Court rightly dismissed the same as being premature. As per the report submitted by the SP of all the districts, the guidelines issued by the court in PUCL have been diligently observed in all death cases. In all instances where police encounters have resulted in death, separate affairs have been lodged, independent investigation has been conducted, magistral inquiries have also been ordered. In its affidavit dated 29th September 2022, the state of Assam has categorically stated that 171 cases have been registered and for that investigations are currently underway. Reliance placed by the appellant in paragraph 31.3 of the judgment of PUCL to suggest that an independent investigation into the incident shall be conducted by the CID or police team of another police station. In every incident is completely misplaced and incorrect. The judgment does not contemplate the registration of FIR at a different police station. The appellant's contention in this regard is thoroughly untenable, as the FIR has been registered by the police station having jurisdiction over the matter. The appellant's claim in this regard would make the investigation unnecessary, onerous, and time-consuming. Similarly, the need for constituting an independent agency would arise only when a prima facie case has been made out that the investigation is not being carried out in accordance with the due procedure prescribed by law. Fair and impartial ministerial inquiry have also been conducted in all incidents where deaths have been caused in police encounters. More importantly, in all these inquiries have been undertaken strictly as per the guidelines of PUCL. The particulars of the stage of investigation or conduct of magisterial inquiry in all 171 cases were placed before the High Court by affidavit dated so and so. So we have stated our stands. Issues for consideration. Having regard to the rival submission, we find that the following issues arise for our consideration. Whether the allegations made by the appellant prima facie establish violation of the guidelines laid down by this court in PUCL. If so, what are the remedial measures? Then analyzing the honorable by the division, the Supreme Court. Then locus also has been conducted, stated here. Now coming to the final outcome of this this case, Lordship, is that
Just a moment.
conclusion at F.
Yes.
Yes. What is the conclusion? I'm not going to the elaborations now. Paragraph 55. Considering the totality of the circumstances and for the reasons assigned herein above, we deem it appropriate to dispose of the instant appeal with the following directions. The impugned judgment of the High Court dated 27/1/2023 is set aside. The order dated 12/1/2022 passed by the full bench of the Assam Human Rights Commission disposing of this issue on the pretext that the subject matter was sub judice before the High Court is also set aside. This matter is directed to be reinstated on the board of the Assam Human Rights for necessary inquiry into the allegations independently and expeditiously in accordance with law. The Assam Human Rights Commission is directed to issue public notice inviting all individuals who claim to be aggrieved, victims and their family members by the alleged police encounters to come forward and furnish relevant information or evidence before the Assam Human Rights Commission. The notice shall be published in at least one national daily and one prominent vernacular newspaper with wide circulation throughout the state of Assam. The notice shall also include the contact details of the officers or the taluka and the district legal services authorities, thereby enabling the victims or their families to access free legal aid. Assam Human Rights Commission may ensure that the identity of the victims, their families, or any other individuals who approach it in connection with the inquiry shall be strictly confidential. Assam Human Rights is expected to adopt robust measures akin to witness protection protocols. During the course of its inquiry, if the Assam Human Rights Commission forms the opinion that a more detailed investigation is warranted, it shall be at the liberty to initiate such an investigation through means it deems fit. For this purpose, Assam Human Rights may engage the services of retired or serving police officers of impeccable integrity and unblemished record, provided that such officers are not in any way connected with the police personnel involved in the alleged incidents. The state of Assam is directed to extend full cooperation to the Assam Human Rights Commission and ensure that all logistical, financial, and administrative requirements for such an investigation are promptly and adequately met. We direct the ASLSA to make legal assistance available to the individuals seeking support in approaching or presenting their case before the Assam Human Rights Commission, for which its member secretary is directed to issue specific instructions to the district and taluk level officers. The appeal is allowed. The above terms pending interlocutory applications, if any, are to be disposed of. So basically, the final outcome of this judgment is that all these cases were taken before this honorable court found that there was lack of evidence. Therefore, it was found to be premature and dismissed the petition, where the CBI inquiry was sought for. They went to the Supreme Court. Supreme Court also said the same thing, that no such inquiry is required. The inquiry is to be done by the Assam Human Rights Commission. So this case also, in my humble submission, falls into the same parameters or within the same ambit under which these 171 cases were considered by the Honorable Supreme Court. So there is no dissimilarity of the present case. And in fact, the present case is in a much better footing in favor of the state.
But Mr. Saikia, there are n number of judgments which say that when violation of fundamental rights are brought to the notice of the court, the constitutional court cannot shirk its responsibility and has to take up the matter. So therefore, when in this case, perhaps because the cases were dismissed, that is why the Supreme Court gave that direction.
Yes.
But in this case, we are live with that issue of the constitutional rights being violated. So we can't, in a matter where we are in session of the matter, perhaps we can't send it to the Human Rights Commission.
No, this case is within the same time frame.
So we understand. Okay.
I leave it to this honorable
We'll
court.
consider it. Okay.
Definitely. So in my humble submission, it is my duty to place this judgment, which is very recent, 28th of May. So today we are on 10th or 11th of June. So hardly 12 days ago, this judgment was delivered.
Oh, yes.
And it was directly related to all these alleged fake encounters, where about 54 persons died and other persons were injured. Total 171 numbers during the course from May 2021 till now. So all these cases were considered, and those cases, there is no such incident that there were cross-border violation of the law and order situation. In this case, the facts were much more critical and crucial, considering the fact that a community-based conflict is going on in the nearby state of Mizoram, Manipur. And they made an attempt to disturb the law and order situation in Barak Valley, where substantial number of people of Meitei origin. If you look at the background, I have given everything, that the conflict in Manipur is relating to basically Meitei and Kukis. Both belongs to two different religions. There are substantial presence of Meitei community in Barak Valley area. About 30% people are of Meitei origin. So in that area, there is every possibility, and these persons also were carrying arms and they were trying to, there is series of incidents where kidnapping had taken place. Series of incidents I have highlighted during the course of last 7-8 months prior to this incident, that about a large number of persons were killed, kidnapped, and large scale of arson had taken place in the same area within the state of Assam. And one particular community is being targeted. So there is no doubt that when these persons died due to encounter, Lordship, in my humble submission, it is definitely the inquiry was going on. We have filed a report also. That is also before this honorable court. From that perspective, Lordship, the present case, which is under session of this honorable court at this stage, it is on a much stronger and better footing than these 171 number of cases. In those cases itself, the Honorable Supreme Court said that go to Assam Human Rights Commission. States were also given the instruction that you give full cooperation. Law, the state level, ASALSA, they are also directed to give assistance to the individuals. So in my humble submission, if the persons are really aggrieved, they can always approach. That door is open for them.
Okay.
So this
May
is
I, my lord, submit just for a couple of minutes, only on the judgment given to your lordship, very briefly. May I do that, my lord? For
Yes.
about, yes. My lord, this judgment will not apply, and more appropriate to this case is the Manipur fake encounter case, that citation I gave your lordship, where, my lord, the Supreme Court said CBI investigation with officers from outside the state. And we cannot have the local state doing the investigation when allegation is made against them. The second judgment I gave your lordship, my lord, was the Chhattisgarh fake encounter case, where once again Supreme Court followed the same kind of model, that it will be done by CBI, but with officers from outside the state. Why I say this judgment will not apply? Because it comes to two conclusions. The High Court came to two conclusions. One is vague pleadings, and the second is no prima facie case. And if your lordships find in my case that the pleadings are vague and there's no prima facie case, I will suffer. I will suffer that fate. But my submission is that the post-mortem reports, for example, which show torture, and the video, and the other facts, my lord, that we alluded to, this is a clear prima facie case in our submission. And it's certainly, my lord, desirous of an investigation by a team outside of the Assam police. That's all, my lord. I'm grateful for the hearing.
In fact, to you, Mr. Gonsalves and Mr. Saikia, since in a different division which I'm taking up a pattern matter with day-to-day hearing, so I have not be able to devote some time in this matter right now. So I'm fixing it after 2 weeks for clarification, if any. After that, I'll
Lords,
pass orders.
Lords.
Grateful.
Heard Mr. Colin Gonsalves, Learned Senior Counsel, who appears through video conferencing, assisted by Ms. D. Ghosh, Mrs. D. Ghosh, Learned Counsel for the petitioners. Full stop. Also heard Mr. D. Saikia, Advocate General for the state, assisted by Mr. D. Nath, Learned Senior Government Advocate, and Ms. P. Barwa, Learned Counsel. Next para. As one of us in the bench within Beckett, K.R. Surana Ji, another bench is involving hearing of a batch of writ appeals on day-to-day basis. Court is inclined to list the matter on 25/6/2025 for clarificatory hearing, if so required.
Sir, can it be 30th kindly?
30, no, there will be a vacation here. Our vacation
From
we
27th
will
to
start from 20, to last court is 27th.
Right, sir. I'll appear on video conferencing on 25th.
Because well, 1 or 2 days here and there we can adjust.
Yes, sir.
1 or 2 days here and there we can adjust.
Or before 21st, if that's possible. I'm out for that period.
Okay. So let us see if it can't happen, then we'll adjourn the matter. Because these 2 weeks I am very deeply involved in the hearing day-to-day
So
basis.
keep it on 25th, sir. No problem. Grateful.
Yes. This order will be in direct petition along with IE criminal. Okay.
Mayfield Lordship, my lord. I have two items, my lord, your lordship fixed today, because several times came earlier, my lord. They were not considered last time, so your lordship fixed today, my lord. So if hearing not possible, your lordship may take up the bail matter, my lord, if not possible. Item, my lord, I am for 19 and 22. Supply. After orders, my lord, as your lordship convening, my. I'm not taking even now, right now, my.
Okay.
Second half, or any time, my lord. It is series, my lord, but I am pressing for 19 and 22, I am appearing.
Okay.
Always.
May I please, your lordship? In daily list item 3, your lordship, we have filed an affidavit in reply yesterday, your lordship. If the same can be called for, your lordship. Obliged.
May it please the lordship, my lord, as it is item number 6, Lord, I was unable to go through the brief, my lord. Can it be taken up next week, my lord? Item number 6, the coroner matter, my lord. Next week, my lord.
Was there a specific reference against the family members also?
My lord, my lord.
There was a reference against all.
My lord.
Okay.
Next week, my lord, I will do it.
It goes after 2 weeks because we are hearing those matters. Item 6. Both sides are represented. The list after 2 weeks is paid for by Mr. P.K. Chaudhary and counsel for the petitioner. Sorry, not petitioner. Petitioners.
May I please, Lordship? My lord, this is a WBC criminal. A lady has been kept in an undisclosed destination since last 25, 5. 25/5, it is kept in undisclosed destination.
You have filed it or you have not filed it?
We have already filed yesterday. It may kindly be listed tomorrow, my lord.
Okay.
Hello.
May I please, your lordship, in the same matter, the whereabouts of a person is not known. We have filed on 5th. Let it come on tomorrow. Much appreciated.
Also, I'm praying for listing of an orders matter, lordship, which got left out yesterday, your lordship, on 12th, your lordship. You come up before the regular DB, your lordship.
We'll make it 13th,
And lordship 18 then, lordship.
18th.
Lordship.
Okay.
Yes, Your Lordship, similar type of matter, Your Lordship, the visitation right has been denied and whereabout the detainee is not known to us, Your Lordship.
Okay.
For tomorrow, Your Lordship. Much obliged.
Lordship, item number 5, lordship. Kindly matter may be passed for the day, lordship. Somewhere misplaced the copy, lordship. Petition, lordship.
Item 5.
Yes, lord. Can be 19th, my lord. Any day, lordship, not today.
We'll make it 18th, not 19th.
19th, madam.
18th.
18th.
5. Both sides are represented on the prayer made by Mr. G. Sharma and standing counsel for the FT matters. List on. What is the? 18/6.
It is.
Supplementary item 14 for motion.
Well, my information is that instruction is that, my lord, he has been handed over to the BSF sector headquarters. My lord, handed over to the BSF sector headquarters, Panbari, Huburi.
Yes.
No, my lord. Here, my lord, this case, my lord, we have handed over the person.
We understand,
Yes.
but wherever if he's not deported,
Yes.
Then visitation right-
Not deported, madam.
Hmm?
If not deported, my
Ah.
lord, it is not known to me because we have handed over the BSF.
it's okay. Heard Mr. M. Datta, learned counsel for the petitioner. For Union of India was there.
RK Chaudhary, I informed, my lord, he
Okay, also had Mr. R.K.D. Chaudhary and DSGI appearing for the Union of India. Mr. J. Payang, the standing counsel for the FT matters. Mr. P. Sharma,
NRC is not a party.
no.
Oh,
So, say, for government. Oh, Mr. Okay, I did not see you. No, it's okay. Mr. I did not notice you. Mr. P. Sharma, additional senior government advocate for the state. Next para. Pursuant to the order passed on 6/6/2025 and 9/6/2025, comma, the learned standing counsel for the FT matters has submitted that that Samsul Ali, comma, the father of the petitioner, comma, namely, comma, Bakar Bakkar Ali, has been handed over to the Border Security Force. Please give the details.
BSF sector headquarters,
Sector headquarter,
Pan,
Panbari.
BSF sector headquarters, Panbari, Dhuburi.
Panbari Dhubri.
On 26/5, my lord.
On 26/5/2025. Next panel. Accordingly, it is provided that in the event Samsul Ali, comma, the father of the petitioner, namely Bakar Ali, has not been deported, comma, the in charge of the sector headquarter, comma, Border Security Force, Panbari, District Dhubri, shall allow the visitation right to the petitioner along with one family member to meet his father, Samsul Ali, and to take his signature in the Wakalatama, comma, if so required, comma, which shall be authenticated by the authority who's in charge of the sector headquarters, BSF, Panbari, District Dhubri. Just say for production of a certified copy of this order, visitation right. Huh? 2 persons visiting right. Before that, you write the copy of the order. To stop. It is further provided that in the event the petitioner has been, the father of the petitioner has been deported, the said authority shall inform the petitioner as to the location from which the said Samsul Ali, comma, the father of the petitioner, comma, named, comma, Bakar Ali, has been deported out of the country. Next para. Give a date after 10 days.
The respondent one, they may also place a report before the Honorable Court, ma'am.
Pardon me.
The respondent one, the Union of India, they may place a report before the Honorable Court, ma'am, with regards to the status, ma'am.
No, since we are giving you visitation right,
That's true, my lord, but they should also, my lord, give me some report.
not required because we'll multiply paperwork only.
Because otherwise, my lord, suppose, my lord, he's not there, my lord, at least they must come up.
Then we'll-
has been reflected by your lordship.
Then we'll pass orders.
Yes, already passed.
We are not disposing of the writ petition.
Right.
We are fixing it after 10 days so that you may give us, you may tell us that it's not there.
Right.
But right now, you see, we are looking at a huge number of people.
Right.
So if for every case we start asking for the affidavit, these officers will be running into the court only for the purpose of affidavits.
Yes.
We're curtailing that for the time being.
Right.
If any adverse thing happens, then we'll definitely
Right.
direct in a specific case. We have recorded your presence. List on.
20 June.
20th.
2020.
Apply.
Daily list item 1 for admission.
Number 203, 215. You are. It came from 121 IMD. Not like any return. Order. May it please your lordship.
Mr. Talra, you have filed an IA in item number 15.
15, my lord.
IA is for?
Yes, for my lord, stay of the, my lord, item 1, 2 and 15 are connected matters.
We'll have it, we'll hear the matters together.
Yes.
My lord,
Yes.
your lordship will just listen for one thing.
No, we have already considered one
Yes, my lord.
in Bikram.
No,
two.
my
We
lord.
have considered
Lord.
that, and on that day, we refused to pass an interim.
No,
My lord,
lordship
because-
is correct. Lordship is correct.
It was on
My lord,
item number 15.
Why, my lord, this 15 is, my lord, listed at my instance.
If your lordship
Is-
will not, because item number 1, your lordship will find what the learned single judge has done, has left the persons without any remedy.
We'll consider that.
But in the meantime, my lord, your lordship will find the illegality will be perpetuated because 5 years will be over by the time the hearing will be done. Because the person who has come before this court,
No, we are not listing it after 5 years.
my lord, it becomes as such, my lord,
My lord.
because now, if your lordship, at least if when there was an appeal by me and there was a stay order, they appeared before the appellate authority and said that I will go after 15 days. They rushed to the High Court against an interim order, got a stay order, and they are running the cooperative society. Let the inspector run the cooperative society.
That is what a comment to do.
My lord,
We have
But
heard.
the
Mr.
government has
Talukdar-
also come before the court, my
We
lord.
have heard Mr. Talukdar
No,
in details
I have yeah, correct.
in this matter. And we were not inclined to pass a, the division bench, coordinate division bench was not inclined to pass. What we have, my lord, and we have decided is, we will fix all these matters for final consideration because the parties have entered appearance.
Yes.
And then let us redress.
Then,
this
my lord,
issue.
very
My
short
lord,
date.
Can I
Because I
submit
am
one line,
expecting those.
my lord? In fact, if I correctly, my lord, remember, your lordship was, my lord, also privy to the division bench. My lord, your lordship had expressed, my lord, once the private respondent appears, my stay application would be considered. Now, your lordship will kindly consider, item 15 has been listed at my behest, only on the ground that, my lord, the coordinate benches are taking judicial notice, my lord, of the judgment.
Naturally.
Yes, my lord, my humble submission is, my lord, apparently, my lord, the order, the judgment which is passed, with all respect, my lord, is in conflict with the scheme. And secondly, my lord, if this continues, my lord, if the, my lord, this honorable single judge judgment is not stayed,
Bikram.
because this, by this judgment, my lord, the ratio has not been settled. Because there are contrary, my lord, views expressed by other coordinate benches.
We will take into consideration everything and we'll rest this issue for once and for all.
Yes.
That's what we, either way. So there is a decision, a detailed, elaborate discussion has been made. We don't want to interfere with that. If required, we'll set it aside. But today, we don't want to stay it. Because a position has been settled, we don't find it's a viable, it's a view that can be plausible view has been taken. So in an intra-court appeal, we'll have to go deep into that.
My lord, my respectful submission is, had it been a case that there were no other contrary coordinate benches, my lord, orders or judgment, then, my lord, I could have understood that
We'll
this judgment
consider
has.
everything. So if required, if the matter so demands, we'll refer to the matter to the Chief Justice for placing before a larger bench. If required.
Larger bench not required because there are conflicting coordinate benches, my lord, single bench or single
See,
benches
we are in the
order.
division bench
Yes,
today.
therefore your lordship
We'll
requires to
have
settle it.
We'll
But-
settle it.
It's not a case, my lord, that by this judgment, the proposition of law has been settled because
Fine,
there are
that-
contrary judgments already.
That is one way of looking at it.
My lord.
There is another way,
Yes.
which Mr. Sinha will argue, that this judgment has taken into account both
Yes,
111 and 92.
I leave it to your lordship.
But my lord, your lordship will just consider one thing. At this very moment, if a chief executive officer or secretary is removed or appointed, what is the remedy?
You remedy, if there is no remedy, file a proper application for that.
But that is what
We'll
my
require
argument
the
is, my
government
lord. My lord,
to
the
take-
learned
But
single
we
judge,
can't ask the government to,
my lord,
act alone.
learned single judge has not
But
dealt
paragraph
to
20.
110 of the cooperative society.
Paragraph 20 gives you that liberty.
My lord,
Right.
that is wrong because 110 has not been considered in Bikrampur. 110, there is an absolute bar for revenue authority, civil court, everybody is barred. Your lordship may look into 110 of the Cooperative Societies Act. My lord, that has not been considered by Bikrampur nowhere. Not a single line on 110. Your lordship in 110 said,
Come to page 101, paragraph 20. It
my lord,
101.
my lord. Nowhere it has said about 110, my lord. That is my argument. The statute provides 110, that there is an absolute bar for revenue authority and civil authority. Your lordship may look into 110 in the act. Bar to jurisdiction, civil or revenue courts. Now, registered is also, there cannot be any appeal to the register. Private dispute, I cannot come for a writ petition. Where I will go? Well, a Cooperative Society Act 110, not a single discussion on that. Absolute bar. The statute provides a bar. Where I will go, my lord? Is there any remedy? In whole Bikrampur, there is no whisper about 110. Your lordship may just look into the Cooperative Societies Act.
will we'll fix in a short date. We'll try to hear it.
But just for I'm placing that by 110(2), save as provided in this act, no order, decision or award under this act for working of the affairs of a registered society shall be liable to be challenged, set aside, modified, revised, declared by any court on a ground whatsoever.
Assam Cooperative Society.
And by just looking into the Maharashtra Cooperative Societies Act and Andhra Pradesh Societies Act, I have brought both this act, my lord. In Andhra Pradesh, there is a cooperative court, and in Maharashtra, there is a tribunal. But there is no absolute bar. I have bought all this Cooperative Societies Act from Maharashtra and, my lord, this Andhra Pradesh. And relying on 61 of Andhra Pradesh Cooperative Societies Act and 91 of Maharashtra's Act. But in both these provisions, there are tribunals and courts. But here, there is only provision is appeal. And bar is 110. Where I will go, my lord?
The same situation was there with the teachers also, provincialized.
My lord.
This court provided for that.
My lord, that
A full bench provided for that.
My lord.
Maybe this is a case wherein your submission may find favor with the bench.
my lord, my
We
lord.
may even proceed on that direction.
My lord, that is what my submission is, my lord. Your lordship will just look into 110 of the, I am placing this book, my lord, your lordship. If a termination has to be declared bad, my lord, the proceedings 110(2), 110(2), my lord. My lord, KVT is appearing in.
Mr. Sinha, my lord, represent for all,
all.
for all, my lord.
Also, turn next, Mr. Sinha, B. Sinha, Learned Counsel appears on caveat for the respondents number 1, 2, 3, 4,
1 to
5,
9, my lord.
5, 6, 7, 8, and 9. Also, accordingly, no formal notice is required to be sent to the said respondents also. However, extra copy of the writ appeal be furnished. One extra copy of the writ appeal be furnished to Mr. B. Sinha. Also, as all the respondents are represented, উপর লিখিবা, admit. Issue notice, admit. Also, in view of, as all the respondents are represented, also, the registry is directed to list these matters again, list these matters for hearing on hearing.
Next week, my lord.
For vacation.
After vacation,
For vacation.
immediately on reopening.
Not immediately, my lord, July
15,
15, man.
15 or 16?
15, man. Hearing day,
Thursday, hearing day, Thursday.
Thursday, man.
16,
16, man.
16.
16 is my lord
16 is
Wednesday.
not the hearing day, my lord. 17 is the hearing.
Oh, sorry. 17,
Yes.
17, 7, 2024.
For admission hearing, my lord.
No, for hearing,
For
finally.
disposal.
For disposal, admitting, we are admitting the appeal. Also,
It will not reach well.
WA 120, 2024.
My lord, we have maybe given a liberty to mention if it comes at the bottom of the list.
Well, that you always have. You don't need an order for that.
My lord, the next case, it is appealed by the registrar. Similar order may be passed. My learned friend, senior friend is representing, my lord, 1 to 9, and my learned senior friend is representing 10. Notice is also complete in this case, my lord.
But
Item number-
Mr. Talukdar, we could not follow only one thing.
My lord.
Why would the state come in appeal?
Yes, correct, my lord. I was just, my lord, submitting on that point. In fact, my lord, the
You see,
department,
we understand one part.
correct, my lord,
The other one part which we understand is
correct.
that because under this act, now every litigation has started coming to the High Court.
My lord.
For small things, now we have started entertaining people have started filing a writ petition and we are entertaining it.
Correct.
And so therefore the alternative is that the authorities will take up an appeal.
Correct.
And you say that this is not under the scheme of the act.
Yes.
Why?
Yes, my lord, correct. My lord, my respectful submission is, my lord, the department is not concerned. My lord, who will be the secretary, Mr. X or Mr. Y? Now, if your lordship goes through the entire scheme, your lordship will find that, my lord, the register is vested with this, my lord, pervasive power in respect of, my lord, supervising, my lord, all the cooperative societies. The supervisory power, my lord, it flows from section 3, and there are other provisions also. Now, by the impugned judgment, my lord, the entire supervisory power has been obliterated, my lord. Now, the consequence, your lordship will kindly see the
Definitely, because
consequence.
You see, had your authorities acted responsibly, then these litigations would not have come to the High Court at all.
No, my lord, here is not a case on merit, my lord. With all respect, here is a case on jurisdiction, my lord. The Honorable Single Judge proceeds to hold that the registrar does not have the jurisdiction, my lord, to decide the correctness or otherwise, my lord, of the decision taken by the board. Now, this particular analogy, my lord, would include each and every resolution. So once, my lord, the registrar is excluded, with all respect, my lord, once the registrar is excluded, the consequence is, my lord, the board is, my lord, vested with the unfettered power to take any decision. Tomorrow the board,
Let him take, why you are worried about that?
no, my lord, the registrar is at the helm of the affairs. It's a statutory duty, my lord. He's not worried, but he has to, my lord, discharge his duty.
Item number two. Writ appeal 120/2025. Seen the office note dated 9/6/2025. Service of notice upon respondent number 2.
My lord, 1 and 2, my lord, my learned friend is representing 1 and 2, and he has filed, my lord, affidavit also.
No, yes.
Huh?
I agree.
Yes, he has filed an affidavit. 1 and 2, my lord, is complete.
Item number 2. Item number 2. Again, number 3. Sorry. Heard Mr. S.K. Talukdar, learned standing counsel, cooperative department for the appellant. Also heard Mr. Sinha, you are appearing for?
1, 2.
1 to 9.
No, 1 and 2.
1 and 2, man.
For respondents number 1 and 2.
Yes.
3 was there.
3, my lord, Mr. Dubey represents. He has filed a, my lord, appeal in the name of Abhijit Chakraborty. I'll give that, my lord, number of that appeal.
No, this item number 3 is represented by
Mr. Dubey, R.K. Dubey.
In 185, Mr. Dubey is a.
No. Your lordship is passing an order in 120.
No, 185.
185. 185, Dubey is not there. My lord,
So, heard Mr. B. Sinha, learned counsel appearing for the respondents number
1 to 9.
1 to 9.
1 to 9.
Yes. And
Also-
10 by my learned senior friend, my lord.
Also heard Mr. P.K. Roy Chaudhary, learned counsel appearing for the respondents number 10. Full stop.
11 is by state.
Respondent number 11 is the principal secretary, corporation department, who would be represented by Mr. Talukdar, who is an official respondent, would be represented by Mr. Talukdar, that is the learned counsel for the. Okay. But no,
That is why pro forma respondent, my lord. Notice not required, my lord. Pro forma respondent.
First up, as regards respondent number 11, who has been incorporated as a performer respondent, no notice at this stage is required, called upon to be issued, as the appeal is preferred by the Register of Cooperative Society,
correct.
Assam. Full stop. Service upon all the respondents is complete. Appeal stands admitted. Registry to list this matter again on 17/7/2025, along with writ appeal number 174 of 2025 and 120.
And for the property for the state, stating differently, but when the power of dealing with the state by a legal, that's why.
This respondent number 11 is not required.
Lordship has struck it off.
Respondent number 11 has been issued as agreed to as submitted by Mr. S.K. Talukdar. The respondent number 11 stands deleted from the array of respondents. in the present debit. Mr. Talukdar shall file an amended clause file.
My lord, let it remain, my lord. My lord, at this stage, your lordship is not issuing notice. I
No,
think this
no,
will
no.
create
You see,
complexity,
there is a difficulty.
my lord,
Supposing we hear the matter
my lord.
and decide it, then your principal secretary will come and say that we have not been heard. No notice was issued and you have decided the matter.
I'm representing the principal secretary.
But you can't be appellant, you can't be responding again.
There are other sets of, my lord, there are other sets of councils, my lord. That they
Tell us the name, appear
Yes,
some.
Mr. G. Wadley will represent, my lord.
Mr. G. Butler accepts notice on behalf of
Respondent.
respondent number.
My lord.
The service of notice of on the all things.
One and two, my lord.
My lord, public.
Item 3 for orders.
In this case, we are supposed to file an affidavit. We have filed, giving the details of the trees to be transplanted. Initially, the IA has been filed in a disposed of case. They have alleged that the commitment we have given, the state of Assam has violated those commitments. So when on the last occasion arguments, I said that there is absolutely not a single inch of violation.
Just a moment.
Yes. Order to put violation, our commitment for the order to put. That if you are saying. Get my purpose. Background sound. judgment of complaint that cover the process.
Before you both begin, we're just trying to think aloud. Number one, whether the translocation of trees would be a good answer. That's one part. The second part is that under the normal circumstances, when there is a when the trees are cut, there are various provisions which are employed by the state. One is compensatory forestation. Now, compensatory forestation, to us, when we think, we are just thinking aloud, we are not forming an opinion. So supposing in this court campus we cut out a tree. So planting of forests, say in Narkasur Hills, doesn't help us. So if the translocation is required and the trees are cut, so there must be some sort of compensatory plantation in the vicinity. That would answer, because there's when we look at this trees which are here, we have seen this from ages since we are kids in this region. They are all very old trees. These trees must have some life. So if the government can assure that there can be some compulsory afforestation to compensate for this, this is one part which you'll have to, I think, address.
Yes. So Lordship would kindly come to page 11. I am taking note of what has fallen from Lordship's mouth now. Now we have to concentrate on the factual metrics of this PL
First,
for the
hear
time.
Mr. Chaudhary first,
No.
so that we can respond to it.
Well, Lord, our perspective is very simple. The assurance given to this honorable court, definitely it was surrounding the Diguli tank. But then the area from which now the state is proposing to translocate the trees, these are not very far away. In fact, Rabindra Bhavan is just across the road, museum is just across the road. Now, my lord, as far as translocation of trees is concerned, my lord, there is a report of the Forest Research Institute, Dehradun, which has, my lord, depicted a very grim picture of this entire exercise. Firstly, my lord, beyond a certain girth, it says it is not feasible. And secondly, my lord, by using those customary tools, I don't think translocation is possible. It can be done by, my lord, very heavy and costly machineries. And in India, as per this Dehradun report, my lord, there are only 12 such agencies who are in a position to carry out translocation, out of which 3 are government and 9 are private. And the agency which has been engaged by the state is not one of those. That is yes. Secondly, my lord, since one arm of the flyover would end in the Lamb Road, and another lamp would end in Milord Robindra Bhavan, then why these museum trees are to be felled or dislocated? First point is that, Milord. Now, if your lordship would kindly have a look at the order which we have quoted in our petition, they have also done it in the IA, Milord. The order is at page number 14. If I may have your lordship's kind attention to page 16. The deponent states that the matter was taken up at the highest level, and accordingly on 5/11/24, the Honorable Chief Minister Assam has announced about realignment of the proposed flyover without affecting the two sides of the Digulipukuri pond and the trees standing therein. As per the proposal, the design of the flyover has been modified, and now one side of the bridge will start from Lamb Road Point at GNB Road, and other side will start at GNB Road near Robindra Bhavan Point, resulting with both the banks of the Digulipukuri, and trees will not be affected in any manner whatsoever. The realignment of the flyover has been decided, and necessary survey and preparatory works are going on for the few new design, and same is yet to be finalized. So what state conveyed to this honorable court on the last occasion was, my lord, that on one arm of the flyover would start from Lamb Road and other from, Robindra Bhavan Point. So beyond that, felling may not be necessary. That is my first point, my lord, which we have brought out in our reply to the affidavit filed by them. Now, regarding the proposed translocation, my lord, there is a recent order of the Delhi High Court, my lord. May I just place that, my lord? That will give an idea of how it is to be undertaken. Yeah. Having regard to Article 43 and Article 21, my lord, now these aspects also have assumed huge importance in our life. Now please have this order, my lord, third page, para 5(2). Or let me read from 5 beginning. Given that the proposed project pertains to expansion of the Supreme Court building to accommodate additional courtrooms, including a dedicated constitutional court, as well as chambers of the judges and essential facilities for lawyers and litigants, the present application needs to be allowed subject to certain conditions which are mentioned below. The applicant shall file an affidavit of a responsible officer indicating the status of 26 transplanted trees that they are being taken care of, along with the 263 planted at Sundar Nursery. The said affidavit shall be filed within a period of 2 weeks from the date of release of this order. The applicant shall furnish photographs after transplantation of 26 trees has been done, so that the learned amicus curiae can see the upkeep and maintenance of the trees. Lordship may kindly skip over to the next page, Roman 5 and 6. Applicant shall also file a site-specific transplantation report. Every year, the said responsible officer of CPWD shall file an affidavit indicating the survival rate and health of the transplanted, as well as compensatory plantation done. That compensatory aspect which your lordship has highlighted. So these are some of the measures which they will have to take. Now, my lord, as far as the Supreme Court's view in these matters, my lord, I'll just rely on 2 paragraphs from a Supreme Court judgment, my lord, that Virender Ghore's case.
Mr. Chaudhary, just a thought came in the mind and I'm asking you.
Yes, sir.
Are you aware that what produces most of the oxygen in the world, in this planet Earth? What is the major source of oxygen generation? Are you aware?
As far as I know, as per our mythology, my lord, this people tree.
No,
No, it is said,
I-
my lord,
I- I
that
recently-
at night also it releases oxygen.
I incidentally at,
I may not be
no,
fully
I'm
aware
just,
of
I'm
it.
just telling you, I attended a conference at my own of this in this nature, and the world's best brains were there, and they explained that it is not the trees which give us the most of the oxygen. It's a wrong feeding we have been getting all throughout, because you see, if there's a plant which gives us oxygen in the daytime, in the night it consumes it also.
Yes.
So the consumption of the oxygen is not accounted for in the entire world.
It offsets.
It offsets. The majority of the oxygen is generated from algae or other microscopic what you call plants which are there in sea.
Okay.
This gives 80% of the oxygen we are having in the earth.
Okay.
And that is why it says that once you disturb the
Ocean bed.
the ocean bed and the this what you call, there's a disruption in the ecosystem of the ocean, it will end in the destruction of human.
Oh,
That's one. I got a second information there which I was stunned. For me, it was a news.
no, even this is
He-
a news for me, what has fallen just now, my lord, to be honest.
I'll give you this. I'll show it from here. The second is that why is the water of Ganges so pure? It says that in the source, from the source where it comes, there are few hills which have certain characteristics, with certain special characteristic
Characteristics.
elements which give purity to the water. And therefore, now when industrialization is started, 10 years back, the quality of Ganges water we had is no longer available. And he showed us maps, photographs of the Ganges falling in the Bay of Bengal, and the quality of the ocean water there compared to others. He said it's a class difference when you see the water falling in. But over ages, he showed us the AI generated Earth's topography from 1 billion years ago till now, the stages of the growth of oxygen in the, how it is done. So therefore, it's a knowledge we get,
Correct.
which was being shared there, is something which I never heard of. This will give just the first one, will give an idea.
And yes, sir, roughly half of the oxygen production on Earth comes from the ocean. Production is from ocean. Plankton, drifting plants, algal, and some bacteria that can photosynthesis. Such one particular species of Prochloropas is the smallest photolithic organism on Earth.
He showed us the photographs of fossils
Hmm.
of 1 billion years ago, and shows us the growth of fossil, the aging of it, and the bacteria which used to grow on those fossils.
Even those also emanate.
Those at one point of time gave oxygen, then they vanished. Now it is the algae and the molasses. In Hindi, what do you call?
Correct, Mila. And we'll have to apply our mind to this and try to find out more.
This algae which we have after the rain.
Yes.
Beside these green things come up.
Yes.
The word in Assamese, what is that?
Yeah, hello. Hello.
Yes, alai. That gives us most of the oxygen. Because it gives oxygen and then it dies.
And because it is slippery, we often try to remove it.
So it gives us oxygen and then it dies. It has a life cycle. It is dead. And this, what you call this planktons and this, what you call this algae or this molasses, you know why it is important? It it leaves elements which destroys carbon.
Okay.
So whatever carbon is generated is consumed by this algae, plankton, and so they are not only giving us oxygen, they are also eating up the carbon which is residue is there. It's just a passing thought.
Very
Nothing
correct.
with this.
That's important news, Milord. But in fact, I thought, Milord, it is from the trees, to be honest.
No, we
And
understand.
among
I
the
had the
trees,
same thing.
people tree, because at night also it releases oxygen. That's why we all pray, Milord.
Yes.
I was trying to refer to the judgment, Milord. 1995 2 SCC 577, paragraph 7. Article 48A in part 4, brought by Constitution 42nd.
Just a moment.
I'm sorry. Leave me alone. It's a news.
Mr. Chaudhary, we have a query.
Yes, Milord.
Number one, we may be wrong because when we read it without any assistance, we may make a mistake in understanding.
Yes,
This undertaking which was given was specific to the Diglipuri area.
yes, surrounding.
Now, yes, surrounding Diglipuri. Now, if we don't know how we will be interpreting, surrounding means whether it goes to the
Across the road.
across the road. That's one. And secondly, we are also noticed that the what you call this PIL is otherwise disposed of.
Yes.
Can by way of an IA, we expand the horizon of the PIL, or you even take liberty to withdraw it, and if you want.
That is one option. That is definitely one option, Milord. Secondly, Milord, PIL itself is an, mechanism where, Milord, normally Lordship will not, apply those rigors which we normally do, because it is not an adversarial thing.
No,
Yes.
but you see,
Milord, there was a liberty given in the order.
come in an appropriate way.
Yeah.
So that can be, it can be an IA, it can be a fresh.
No, normally, Milord, had it been an adversarial litigation, certainly a dispose of writ petition cannot be reopened by an IA. Milord, that on that I'll not make any argument. Only considering the fact that it is a PIL, where Lordships has been pleased to, Milord, liberalize the regime. Now, if your Lordship feels that we should come up with a fresh petition, we can do.
No,
But
we are not suggesting it, but
Yes.
that's, I think, would be more better. Because the PIL has been disposed of, giving you liberty. Liberty can be an IA, it can be a fresh PIL.
File a fresh petition, Milord.
This is a
Oh.
sure public interest. Now, what was there in Digilipukri that has been taken
Taken
care
care
of.
of.
But here, maybe because of the developmental activities, some translocation may be called for.
Yes.
How do we go about it? If you can also assist, bring it on record with the
No,
materials.
having got
It-
the Delhi High Court's order and other thing will now come up.
Because Delhi High Court also has permitted,
No, Milord,
but in a particular manner.
Yes.
So here, this IA may not be the correct approach. If you can file a PIL within
We'll
a short
do that.
time, we will.
No, we'll do that.
So we close with liberty. Mr. Saikia, we granted
Yes.
liberty.
Yes. The dismissal word may be inserted. The IA is
No, we-
dismissed, that word may be dismissed.
We will close it.
Because after filing my affidavit, and there's a reply to my affidavit also,
No, that-
I was
okay,
expecting a
but
proper
we are-
hearing, and I am prepared with all the Supreme Court judgments today.
Mr. Saikia, you see.
There is a concept called sustainable development.
No. What?
And
what-
these gentlemen's, now the Supreme Court has given the responsibility,
Mr.
who is
Saikia.
raising objection,
Mr. Saikia.
in the compensatory nature, they will have to take care of all the plants. I
No,
want
Mr.
that observation from the Supreme
Mr. Saikia, you see what we told is, when we read it alone, without any able assistance, we may tend to miss out many things.
Court. What is most important, they were trying to mislead this honorable court by saying that we have violated the undertaking
No,
given.
that's okay.
There's a, which without assistance, Lordship read it correctly. That there,
Yeah.
we have not violated anything.
It's not
You
adversarial. Mr.
may
Saikia.
reserve that
It's not
because it's not
adversarial.
adversarial.
It's for all of us.
Today, when we first round of arguments, I made a submission that lot of trees are of danger in Dighalipukhuri. It may fall anytime on the people also. And there is a huge tree which has fallen down, and our GMC people are scared of touching it now because of the litigation. We have to remove it. Lordship will go while crossing Niloy Dotto's bank opposite. The tree is fallen there, but nobody has dared to touch it now.
Our
But
order
we'll
should-
take a liberty and do it.
Our order should not be construed that
No,
when
no.
a tree falls
No, no,
down
the-
on its own, that you are not in a position.
we
to
say
do.
that there is what we wanted to do earlier. We have changed the whole we have realigned the whole project. Anyway,
It's
Lordship,
okay,
in
let's
my next
reserve it.
round, I will
We
open
will
my
reserve
card,
it,
not today.
Uh,
But
Uh,
that observation by
Mr.
Supreme Court is very
Chaudhary.
interesting. Who have raised the objection, they will have to take care of the
no, it's
compensatory
okay.
nature of afforestation.
Just a moment. Mr.
There
Chaudhary.
is a concept called Kempa.
No,
And
that's
this
why I
concept of compensatory afforestation has come from that. Normally, my lord,
Mr.
that
Chaudhary.
fund, there is a fund.
Mr. Chaudhary, I'm just asking you because you are appearing in the matter. We record some submissions, or we can say that you will withdraw it.
That will file a fresh liberty may be given to us.
Heard Mr. Kane Chaudhary, Learned Senior Counsel, assisted by Mr. V. Rajpal, Learned Counsel for the petitioners. Oh, sorry, applicants, will be applicants. As well as Mr. D. Saigal, and Advocate General for the state, assisted by Mr. D. Nath, Learned Senior Government Advocate, and Ms. P. Barwa, Learned Counsel. You're also there? Yes. Yes, for the board. Respondent number? Oh, respondent number 4. And PWD? Oh, you have copied.
We have.
So this is Saikya for respondent numbers, Mr. Nath. And Ms. Birwa for respondent numbers 1, 2, and 3. And Mr. S. Barwa, and it's standing counsel for respondent number 4. Next, Birwa. In view of the
for hearing upgraded item 19 to 23.
Yeah, Lordship, before my learned senior makes a submission, my lord. But here in this case, my lord, Honorable Justice S. Jahan was dealing this case, my lord. I have just few minutes back when I received the paper books, my lord. Can it be any date on next week, my lord, if possible, my lord?
I have given all the papers to him, my lord.
My learned senior has
Yeah.
given.
Day after tomorrow is possible, my lord.
More certain, line up more to time of the cases.
Even otherwise, I'll not be able to hear the matter because of the day-to-day hearing we are taking up. We have a timeline to be adhered to in that case. We can fix, the earliest we can fix the matter is on 25th of June.
25th. Well, instead of hearing matter, the IA can be
No,
taken
that
up.
IA also same orders,
Yes, sir.
we are allowing you to, we are permitting you to move the IA.
Can it be, my lord? Date as soon as prior to that, my lord, if possible.
And
The
this,
second time, your lordship, my lord, what I can say.
24th is a Tuesday. We can keep it on that day. But this EPSC series, since we are hearing day to day, we are not in a capacity to take any more hearing.
No, the capacity is there, but time constraint.
No,
That
it's the capacity because there is a bunch of 50 appeals together.
That's true.
That appears.
We answer, we feel like that is there, my lord. We have some constraint, what can we do, my lord?
No, we understand you are considerate, but
Well, lift your lordship, my lord, because
okay, 25th.
we have to see
24th.
both sides, my lord.
24th is a Tuesday.
It will come for orders or hearing, man.
We just like today, you make a prayer, we'll take it up. It's HR Judges and Senior Counsel.
I'm for item number, my lord, 19 and 23. With my lord.
For the appellant in, for the applicant in IA Criminal 307 of 2024. Is present. Along with learned counsel for all the connected matters. Next paragraph. Mr. R. Kaushik Leonard, APP, pays for some time to address the court. So accordingly, matters is adjourned today. List on 24/6/2024.
I'm listening.
Mr. Chaudhary, make a prayer, will accommodate on that day.
Whether this bench will be, my lord, because this is titled, I think, your lordship.
Pardon me?
I think this is titled, your lordship, this matter, my lord. Whether.
No.
Huh?
No, but since we are taking up the bench 2 and it's tagged with bench 2, that's why it's coming.
Mr. A is there, my lord, I think court number 9, Mr. M. Bora is not appearing, so that's why it has come to your lordship.
Okay.
Yes.
Okay.
Obliged.
Item 4 for hearing.
Well, on last occasion, Lordship has allowed us to send back the case diary and to have the further progress of the investigation. Well, I have today in the morning, I have received back the case diary. The the entry in the case diary, I have seen the IGP range, my lord, he has the IO has been new IO has been appointed, and the IGP range has taken a meeting, and ultimately both the cases have been given to two new IOs. Their their DSP headquarter Hamren and DSP level officer, my lord. And my lord, they have followed yes, my lord, prayed for some time, my lord. So on 2/6, the update is there in the diary. Otherwise, my lord, from the last IO, here, my lord, the difficulty was that a postmortem report available in the case diary was in carbon copy. And some materials are there, my lord. I took the clarification from the IO. I have taken that.
Lordship had observed. There are more questions, and your Lordship had observed number of aspects, your Lordship, discrepancies
Yes,
in the
yes.
case diary earlier, your Lordship. And 8 IOs, this 8 IOs have changed hands, your Lordship, over 8 years.
Kindly take the last page of the case diary, my lord. That is the last note I have seen on 2/6, and then the case diary has been sent back again.
Mr. Rajpal, I forgot the context. This firing incident resulted in loss of life.
Lordship, so what has happened, your Lordship? One call was given. By the-
2 persons had died.
Yes, 13 persons were injured. 51 rounds were fired, your Lordship, and 2 persons succumbed to their injury, your Lordship. One, your Lordship, he was brought to Guwahati. According to the CD, your Lordship had observed that it was your postmortem was done in JNRC. But when they sent the postmortem, your Lordship, which is a carbon copy, was from the GMCH. Another person who succumbed on this way was taken to Nagaon Hospital, your Lordship. And his PM report, at least still on the last status report, was not yet available.
No, PM is available. Or as regard the Nagaon, the person who died at Nagaon Hospital, PM report is there. The second PM report, it was the original copy was not available. In fact, other documents are available in the case diary, my lord. The Dispur, Dan Malad Bhangagar PS was not there. It was Dispur PS. Through proper channel, my lord, ultimately they have collected the copy from the GMCs, and the WT message where Lordship has, my lord, indicated, my lord, that the postmortem was conducted at GNRC 1 IO has, my lord, written that was in fact not correct, my lord. It was not correct. The GNRC has, the body was taken from GNRC and taken to GMCH for postmortem. Other materials are there, my lord. In the case diary itself, it is there. That WT was wrong, my lord.
Did the Human Rights State Human Rights Commission and made an inquiry in the matter?
Probably not, Your Lordship, not to our knowledge.
State or National Human Rights Commission? No, you're not aware of it.
Not to our knowledge, Your Lordship. I don't think so, Your Lordship, otherwise it have. Your Lordship.
What is point?
Well, the concerned range IGP, he has taken a meeting of all the pending cases, including both the cases. These two cases are also there. And that meeting was recently held, Mulad, and accordingly to the investigation has been handed over to two new IOs. That is available in the case diary, Mulad. At the last page,
Certain
Mulad.
observations earlier in regard to the case diary itself, Your Lordship. That way, it was not numbered earlier. And proper continuity was also not there, as per section your 172 1B, Your Lordship, which requires that it shall be in a volume and duly paginated. Postmortem report also they had sent was carbon copy, Your Lordship. Whether X-ray was conducted, whether proper autopsy was conducted, there are a number of questions, Your Lordship, which are arising. Even the ballistic report was not available, Your Lordship. The 51 rounds, whether the arms were seized, Your Lordship, and a ballistic report, an armory report is available, Your Lordship.
Is the magistrate report available here? In this case diary?
Page 40. Page 41. It is annexed in the affidavit in opposition, Mulad. Page 41. Affidavit by Mayank Kumar. Page number may not tell you, Annexure D. Affidavit starts at page 61. Affidavit of respondent number 5. Mayank Kumar.
It was around in the afternoon, around 2. If your lordship come to the SP report,
So we'll come to just, we are trying to read the case diary.
lordship.
But there is
There is-
second inquiry report is also there. We filed an affidavit in the month of September 24. One-man inquiry commission was appointed. That report is also there.
Which page?
It is, my lord, the affidavit filed by Abhijit Sinha, September 2024. at around one
This is a report by
by B.V. Pyarelal, Additional Chief Secretary, Government of Assam. At last,
this is March 4th.
March 4th of March 2018.
No, this report is no report at all. This report is not worth considering. You come to page 89. During the hearing, none of the members of the public refuted the fact that the agitators went out of control and public property was damaged. The complaint of the people was that the police resorted to firing without giving any announcement of or tear gas firing. Secondly, the youths were fired at their head and chest instead of the lower part of the body. According to public, this shows that the intention of the police force was to kill the boys rather than to control the crowd. Now, if none of the members of the public were heard, how does this finding come? According to public, source, what is the source?
Well, they said during hearing, none of the members of the public refuted the fact. They were heard, but they have also agreed that there was a agitation and that went out of control. At 1:30, when the SP and the DC
See, most
reached
of
the
the public
place.
did not participate, Your Lordship, in the inquiry.
You see, we are saying so because come to page 87.
Malad.
List of persons present at hearing is annexed as A.
A.
A is not here.
A is not. A is not.
So therefore, we are supposing that the people are not there. But in an inquiry like this, you would have referred to some evidence collected during the course of hearing. Now, even if somebody says in the public that the intention was to kill, at least the one-man inquiry should have at least seen the postmortem report where the injury was. If the injury is in the head and chest, if this report does not deny, that means it goes against the state.
There is no match.
Presumption is that it goes against the state.
There is no
The police force was used to kill boys.
Well, it was around 400, 500 persons were
So,
there.
we understand, even if
Violent agitation
even
was
if in
there.
4,000, it is 400, even if it is 4,000. But if somebody is shot, then there will be accountability against the state. The allegation was that you did not give information to the people, there was no tear gas firing, and then this happened. But contrary, this case diary contains a seizure list where the tear gas shells are found to be seized.
Well, whatever in the particular paragraph has been recorded, those are the from the public side. They said that there was no tear gas burning.
You see, how does the one man committee should do? Let us say you appoint a person who has no knowledge of law. He is an ordinary man. From the streets, you catch him and then say, please do an inquiry. Then this one way. Second is that he is the additional chief secretary. You ask him to do it. That means his basic training for a magistrate is already there. Because under 176 of the CRPC, it's an executive magistrate who will do this inquiry.
It is done.
And therefore, this person is deemed to have knowledge of how the inquiry is to be made. He refers to no document at all.
Some reports he has indicated, but it should have been elaborate. I do agree, Malad, because so many aspects he has not mentioned. Two inquiries at government level, one-man inquiry committee, this is the inquiry, and the other 176 inquiry is also there.
You see again at page 89,
Malad.
serial number 2. It is not a fact that the police did not try any other method like tear gas to control the mob.
Logic.
But what was done? What is the site? Where was this person killed? It does not even refer to the status where the police firing took place.
Three, Malad, he said, serial number 3.
Pardon me?
Serial number 3, just Lordship has read 2, and serial number 3, he says that the boys were hit by bullet on the upper part of the body since the police force fired from a height they played from. It was a railway station, Malad. In fact, some